stall. Those that would stand still of their own will were milked in the middle of the yard, where many of such better behaved ones stood waiting, all prime milkers, such as were seldom seen out of this valley, and not always within it, nourished by the succulent feed which the water mead supplied at this prime season of the year. Those of them that were spotted with white reflected the sunshine in dazzling brilliancy, and the polished brass knobs of their horns glittered with something of military display. Well, those bucolic words from Thomas Hardy's Test of the D'Urbervilles are probably what you picture when you think of a cattle pasture. That is not what the Minnesota Pollution Control Agency thought of a certain cattle pasture and what we call a feedlot, and so fined that farmer several $100,000. That case went to the Eighth Circuit, which is something we'll talk about today, along with the return of an old property rights friend here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Wednesday, February 26, 2025. And as I hinted there, a property rights special guest is featured on today's show, someone who has been on Short Circuit in the past, and it's been way too long since we've asked for him to come back. So we'll get to him in a moment, but also joining us, and we'll be discussing this feedlot case from the Eighth Circuit in a little bit, is IJ's very own Justin Pearson, who is the managing attorney of our Florida office, is in charge of our nationwide food trucks litigation, and also many of you listeners will know that he is part of our Supreme Court preview every fall, but he has some additional previews in the works that he'd like to tell you about.
Yeah, that's exactly right, Anthony, as I turn off my email notifications. Sorry about that. So I am fortunate to oversee IJ's Supreme Court term preview series that we do at law schools every fall. It's a lot of fun. I'm joined by other IJ attorneys and professors. We did it at 6 law schools this past fall: Harvard, Chicago, UVA, Duke, UNC, and Wake Forest. And it looks like this upcoming fall, we're going to do it at 8 or 9 law schools. And so if anyone out there is at one of our nation's top law schools and would like to be added to the list, I can't promise you that we'll be able to fit you in because it is getting pretty busy in a great way, but feel free to reach out to me directly. My contact information is on IJ's website, but my email address is jpearson@ij.org. And it's really this cool event, and it's been so much fun to see it grow. I know, Anthony, you've participated in years past, and now the idea that we're closing in on 10 law schools is pretty neat.
Yeah, that's crazy. It all started with humble beginnings at the University of North Carolina, and now it's all over the place. So if you're interested, contact Justin. And now for our special guest, he is, I'll let you guys relieve you of your waiting. It is Robert Thomas. Now, Robert wears many hats. He is director of property rights litigation with our friends at the Pacific Legal Foundation. He's a longtime property rights lawyer. He blogs at Inverse Condemnation Blog, which if you are at all interested in property rights and you've never been to, you are really missing out. We will put a link in the show notes to it. He is also the Joseph T. Waldo Visiting Chair in Property Rights at William and Mary Law School. He is a contributor to the Bound by Oath podcast, where he was an interviewee earlier in this season and even accompanied John Ross, our colleague, on a trip to Pennsylvania to look at its coal mines. I'll let him maybe talk about that in a moment. And he was on Short Circuit way back in the day when you had to come into the studio, our studio in Arlington, Virginia, which he did. And I think that was back in like 2019. So Robert, it's great to have you back.
Well, it's great to be here. Thank you. And thank you for that introduction. I forget sometimes what it is, which hat I'm wearing. And speaking of that trip, I call it John and Robert's Excellent Adventure, if that gives you any hint about what we were doing, traipsing around in the snow on the 100th.
Yeah, and there was time travel even.
Exact 100th anniversary of our favorite case, Pennsylvania Coal Company against Mann. John even uncovered a murder mystery that came through in the Bound by Oath podcast. So it was an interesting, nerd-filled 2 days that only certain ones of us could be talked into it. And John said, "Well, let me think about Robert." So that was quite fun. So thank you, and thank you for having on, especially a let's call it a friendly competitor for some cases and issues, but in all seriousness, right? We're all pulling in the same direction, maybe from slightly different angles, but we're all going in the same way, and we celebrate each other's successes.
Yeah, well, thank you, and we of course are very supportive of many of the efforts at PLF, and have you guys on here from time to time. This week, so we asked Robert to come back and present whatever case he wanted. And interestingly, for Short Circuit, one of the cases he picked that I thought was really interesting was from a state case, which we do occasionally, the North Carolina Supreme Court, which has an interesting recent property rights case. And I should add, we have had a few North Carolina Supreme Court cases we've talked about in the last couple of years because IJ has been litigating there. Justin actually has a case in the lower courts there. Our friend Josh Wyndham had a victory there a few months ago. But then there's this case on property rights issues that has a lot going on. So we'll have Robert present that in just a moment. First, a couple very quick announcements. A couple months ago, I was touting that I'm going to be at the tavern debate that IJ does jointly with the Federal Society every year at the Western Chapters Conference. So on the West Coast in Westlake Village outside of LA. That was unfortunately delayed because of the LA fires. It was going to be at the end of January. It has now been rescheduled, though, for March 28th. So I'll put a link in the show notes if you would like to join us, meet a few IJ attorneys, and participate in this really fun event. You can sign up Friday, March 28th. And of course, we have upcoming the 10th anniversary of Short Circuit. That's April 3rd in Washington, D.C. So we're going to be coast to coast within just a few days. We have had a number of RSVPs. We are not quite at the sellout point yet, but it is getting closer. So if you want to come to that event, please RSVP sooner rather than later.
Short Circuit is like the Law and Order, I think, of the podcast world. Did you see that bit? And I forget what self-congratulatory award ceremony they had, and one of the actors from Law and Order said, "Who in the audience here has been on Law and Order?" And like 3/4 of the audience raised their hand. You got to ask that question of your audience at your event, and I bet you're going to get a big return on that. But yeah, you guys are the Law and Order, I think, of the podcast, legal podcasting.
That's a great point. We will be sure to ask that of the audience. So we'll turn now to North Carolina, and as I said, there's a lot going on in this case, and kind of almost the least interesting part of it is the merits.
Yeah, exactly. And we've often our brethren across the Atlantic often give us American lawyers heat by saying you guys care more about this Magna Carta thing than we ever did.
But maybe they should.
Maybe they should. Exactly. It took the American Bar Association, as I remind them, to go fix up that monument at Runnymede and put it in. To them, it was just an open grassy field down by the river that they paid no mind to. But if you go there today, there's a plaque and a I won't call it a memorial, but a commemoration site where you can say, here was the spot when the barons forced John to affix his seal to this thing that said he would, at least in principle, respect their rights. We all know that didn't last, 90 days. I don't know. Was it the ink on the parchment? I'm not sure what they used, but it wasn't, the ink wasn't literally or wasn't dry on the document before John said, the heck with this thing, and threw it out. But over time, successive kings affirmed it and reaffirmed it until the Parliament finally adopted it, and this and that and the other thing. But it's had more life, I think, in American legal memory than it has in our British counterparts. They rely on things like the Bill of Rights and other things. Well, anyway, and anybody who reads property rights decisions in the U.S. out of the U.S. Supreme Court these days knows that it's become much more frequently relied upon by the court, the Supreme Court, and this thing Magna Carta. It's right there on the courthouse door, right as you walk in. But it has been by reference, but there's actually one state in the country that has almost a direct a copy of language from the Magna Carta translated from the Latin to English in its state constitution. And one of the things I talk with my students, I said, well, what if we didn't have this thing, public use clause, takings clause, in the U.S. Constitution? Does that mean that, well, government could just take your property for any use and doesn't have to pay you? And in other words, is it the takings clause that stands between us and land grabs by the government that go uncompensated? And they finally work around to, no, that just doesn't seem fair. And I said, well, we've got one example. When I met William and Mary, one example, one state south, and that's North Carolina, which does not have a due process clause in its state constitution. It doesn't have a takings or public use clause. And yet, last time I checked, the North Carolina Department of Transportation pays compensation and worries about things like, is this taking for public use? And it's because the North Carolina Constitution has a law of the land clause that has been interpreted over the years by the North Carolina Supreme Court as having some of the same effects as what the U.S. and other state constitutions separate out into due process clauses or takings clauses or just compensation clauses or whatever you might want to call them. And the language, if you go check it out, the law of the land clause almost mirrors exactly what was in Magna Carta. No person shall be taken, imprisoned, or disseized. Us old dirt lawyers love disseized of his freehold, liberties or privileges, or outlawed or exiled. I like that one. You can't be outlawed or exiled. Robin Hood. In North Carolina, or in any manner deprived of his life, liberty, or property, but by the law of the land. And so North Carolina Supreme Court has said that encompasses both a procedural aspect, much like procedural due process. It encompasses a substantive, arbitrary and capricious principle, limitation on government power, much like that thing we call in the United States, other parts of the United States, substantive due process. So here's a, flag up to Justice Thomas, Clarence Thomas, who says that this thing, substantive due process, it's so internally confusing. Well, Your Honor, how about law? Would you prefer law on the land? And it also, according to the North Carolina Supreme Court, picks up some of the same things against, let's say, ex post facto laws or takings and public use. And so a case came up. The North Carolina a few years ago adopted a law that went back and essentially took a can opener and reopened tort claims in which the statute of limitations had expired under North Carolina law. And they said you can go back and revisit some of those cases for a limited period of time. And of course, that would trigger, I think, in all of us who are into limitations on government power, sort of the idea, whoa, can they do that? And that was the issue in this case, McKinney against Goins, that was decided on the last day of January 2025. And it's a one of those cases where it's a interesting, great principle, a fascinating case. But what was the statute of limitations and what were the tort claims that the court or the legislature reopened or was extending? It was more of a reopening because those claims had actually, the statute of limitations on those claims had elapsed or lapsed or I forget what the term is, but had ended. And so the putative tortfeasors were probably breathing a sigh of relief if they had in their hearts committed torts during those times. Well, anyway, here's the rub. It was for child, fooling around with kids. I mean, that was the part. And
Bad stuff.
so exactly. And it's not exactly the kind of case that's going to engender a lot of sympathy for the challengers, for the claimants. Hey, I thought I was in the clear because I was a potential tortfeasor for that tort. Oh my gosh. Does it seem fair to go back and reopen these claims against me and subject me to liability or potential liability? So, in this case, if this was in any other jurisdiction, we might be looking at under maybe a due process theory, or I know it's only criminal claims that you deal with ex post facto, but it kind of has that same vibe, going back and subjecting someone to liability for an action that they thought that they were in the clear. But in this case, it had a strong, very strong takings vibe, I would call it. But the challenge was under North Carolina's law of the land clause. So this violates the law of the land. You're disseizing me of a liberty, privilege, or my property that's not in conformity with the law of the land. Law of the land essentially says that once tort claims have passed, according to this thing that the legislature adopts called the statute of limitations, they're gone. You can't go back without taking, let's call it, my property. And here's where it gets even more interesting. The North Carolina Supreme Court, when it gets the case, all justices are in agreement that the North Carolina legislature can do this thing without running afoul of the law of the land clause. It's how they get there that got really interesting. And then there was sort of an unanswered question that I was like, hold on a second. Okay, whichever method of interpretation. And that was the big fight on the North Carolina Supreme Court. The majority said, we're going to look at the text. Okay, check. I think we're all good with that, right? It's the text of the Constitution. When our brothers and sisters across the pond, I asked them, you love your Constitution? They say, of course we do. And I said, well, show me. American, we can pull out our pocket constitutions or even our pocket state constitutions or, WWW law of the land clause or whatever it is. But they can't, right? They show us little scraps of paper. They say, no, the British Constitution lives in our hearts. And it's like, okay, thank you, right?
History and tradition.
There you go.
And I will interrupt to refer the listeners show we did a couple years ago on the British Constitution by a couple of British constitutionalists that are very proud of their kind of unwritten constitution. But I think on balance, having it written down in one place, it's kind of a good idea.
Yeah,
Agreed.
Up until then, no constitution, up until ours, our U.S. Constitution, and of course our state constitutions preceded that. No one had written it down, and in the time since we wrote it down, no new constitution hasn't been written down. And what does that tell you? But anyway, yes. So the question was, is this consistent with North Carolina's law of the land clause? And the court unanimously said yes. Legislature can do this. And the real divergence was in how to get to that result. They all agreed that the first place you start looking is at the text of the North Carolina Constitution, but then the question is, what do you do with that? And the majority came up with a rather detailed, rigorous, step-by-step, look there. Then you look, if that doesn't help you and get you to where you want to be, look to the context at the time, look to our decisions, and start with our most recent decisions, or start with the decisions that were recent to the adoption, and work your way forward. Well, the dissenting judge or justice wasn't having much of that, and she argued, look, that, I think her words were, that fixes the North Carolina Constitution in amber. Remember, we got a little bit of one of the same things. We got a little bit of uncomfortable history in our constitutional history in North Carolina. At one point we thought we were seceding from the Union, and other things, and of course points out that life of the land or law of the land might have protected the ability to keep other human beings in chattel slavery. But the debate between the majority and the dissenting justice, very, very interesting for us who are witnessing that same debate going on both in the halls of legal academia but also in courts. And also at the same time, the U.S. Supreme Court majority, when it comes to property cases especially, is saying, look at history and tradition, right? All of a sudden, constitutional lawyers, property rights lawyers, have to go back and dust off our Blackstone or Cook, all the things that we maybe left behind a little too much from law school. But Chief Justice Roberts is when he writes his opinions, particularly, will really emphasize things about, let's start with Magna Carta and move forward. So I think this case is a great reminder to do so. And so really commend the issue or the case, the decision, to the listeners, even if you don't at all follow what goes on in the judicial politics, let's say, of North Carolina Supreme Court. And I understand from my local colleagues there that a lot has been going on in terms of the changes as new justices get elected or decide to run. But the interesting thing to me also about this case that gave me a little pause, I don't know how to interpret the North Carolina Constitution, and I imagine that beyond the borders of North Carolina, that debate doesn't resonate all that much, except of course, every state is doing this with our own constitutions in our various states, or as a model for how the U.S. Supreme Court might do the same thing. But the interesting part to me, and the one that gave me a pause, is that what I thought was a very strange analysis, and the way that the majority got there is they say, well, you didn't have a property right in the running of a statute of limitations. Well, okay. What do you mean by that? On one hand, it sounds good, right? Statute of limitations is a government benefit to some degree, right? It's legislative gravy, or legislature simply determining an arbitrary point in time after which you cannot bring a claim. And the court said, well, hey, the government gives, the government takes away. What's the big deal? Well, okay, but and these guys, you don't vest into a no liability situation simply because the statute of limitations is run. Again, triggering my old dirt lawyer thinking about vested rights. Oh, you don't have a vested right in a statute of limitations. Well, all right, okay, I'll put that down. But here's what kind of stuck out against me. Or stuck to me. It said, the statute of limitations simply says you can't use the courts. It doesn't say anything about the underlying claim. So, hey, defendants, even though the statute of limitations ran on you or claimants who might have been tort defendants in one of these cases, you were still subject to liability. So therefore, you haven't really lost or gained anything by what the legislature has done, and it's only opened up an avenue in court. And that's what really got me thinking. So wait a second. Before this adoption, there was no legal remedy to pursue a tortfeasor. Now there is, again, for a limited period of time. Is the court really saying that the claim, even though the statute of limitations passed, that the claim was still good? And I ask you guys this, what good is a claim if you can't seek a remedy? A legal remedy, right? And I think the court was playing a little bit of a little sleight of law, or maybe a little sleight of policy, or whatever you might want to call it, because it's logical and it works out. Oh, you have no property interest in a statute of limitations because a statute of limitations merely cuts you off from going to court. but you have all your other remedies and you're still there. You are still subject to a claim. And I'm like, what claim? Meet me in the courthouse square at 12 noon and we'll shoot it out and have a trial by ordeal. I mean, what remedy might a plaintiff have once blocked, once a statute of limitations expires, or I don't know. And so I ask you guys that, and it goes to me where it cuts back to me as a property lawyer is the question of these self-executing rights. On one hand, we have the Nevada Supreme Court in a recent case saying, every right under our state constitution is self-executing. There's a damage remedy for that no matter what. The legislature doesn't have to hand these things out and say, yes, we agree that the Nevada state and its instrumentalities can get sued for money if they allegedly violate your rights. It's self-executing across the board. The U.S. Supreme Court on down has said on things with respect to takings and property, the right is self-executing. The North Carolina Supreme Court itself has argued and is awaiting decision on a case involving what remedies, self-executing remedies are there, if any, for a failed condemnation in which the condemnor, even after being told by the court this taking isn't for public use, goes ahead and takes it anyway. So who knows? But I would be fascinated to hear your thoughts on a client walks in your door, says, I think I have a claim against, B. A walks in and says, I think I have a claim against B. Oh, really? When did the first question we ask, when did this happen? Well, about 50 years ago. Oh, yeah, I'll take that case because the North Carolina Supreme Court says even though the statute expired and we can't go to court, we can do other things. Well, what? Maybe I'm looking at it too much through the lens of the lawyer. Am I? Where everything's resolved in court.
Well, Justin, do you have the answer for us?
Well, the short answer is I don't think I'd take that case. But what I do want to say is, Robert, I'm so happy you chose this case because this disagreement between the justices over whether precedent from the closer to the time of ratification is more valuable when determining the original public meaning than subsequent precedent is something I'd actually been independently mulling over because of a talk that I saw recently. I went to a talk where Florida Supreme Court Justice John Coriel gave a speech hosted by the Broward County Florida Bar Association as well as Federal Society, and it was open to the public. Anyone could attend, and I believe he's probably expressed these views elsewhere as well. But it was a talk on textualism and original public meaning, and one of his big points was that when you're looking for the original public meaning of a textual provision, the precedent from that time period, the first precedent to apply that textual provision might actually be a better indicator of the original public meaning than the subsequent precedent, which I know is the type of thing that could make lawyers uncomfortable because it's not how we're used to viewing things, right? Normally we're taught that the subsequent precedent overrules the earlier precedent or is kind of more impactful and deserving of more weight than the earlier precedent. And so I've really been mulling that over, and I've come to the conclusion that, yeah, there are times where I think I do believe with Florida Justice Coriel as well as the majority in this North Carolina Supreme Court case, that, and this is not to say that subsequent precedent is not worthy of any weight. It depends on the situation. It depends on how they grapple with the textual analysis. But I do agree, and I've given this quite a bit of thought, that at least in my opinion, there are definitely times where from an original public meaning perspective, the earlier precedent has more value than the later precedent, which is kind of wild to me, but I think that's right.
Yeah, and we see that a lot of times implicitly in the U.S. Supreme Courts and other courts. I mean, you cite something by Chief Justice Marshall, right? It's sort of super precedent, or kind of, there's a little, asterisk by the precedent. Hey, this was John Marshall, sort of that guy, right? Or you might maybe see it from in terms of persuasive logic, not so much the text, but from certain other justices throughout the history, but particularly when it comes to textual interpretations and what words meant. Chief Justice Marshall's opinion seemed to be just this a little bit above, held in a little bit above, because, hey, man, he was there. right?
Well, I
Yeah.
will give as a counterexample to what you guys are just saying, not would necessarily disagree with you, is of course a case that was close in time to constitutional text being adopted was the slaughterhouse cases, which, as we
Yes.
all agree, slaughtered the meaning of the 14th Amendment only 4 or 5 years after it was adopted. So,
And clearly wrongly decided.
yeah, is
so
that
that's a great
oh, we
counterexample.
should
Right,
just stick to
example,
that
and
original, meaning.
for
I
sure.
think there was a really interesting. I want to address your point, Robert, about the property right and the remedy angle, but there's a really interesting back and forth between the concurrence and the concurring opinion and the majority opinion on what I think the concurring justice called reverse originalism is how she put it. Maybe it wasn't that exact phrase, but I liked it a lot because there's this debate about. So the North Carolina Constitution was first adopted in 1776. Then they had a Reconstruction Constitution, and then they had this kind of revamped Constitution in I think 1971. And so the majority takes a lot of time saying 1971, that was just rearranging some things and they were cutting some extra words, but they weren't really changing the meaning that much. And so we shouldn't look to that much to the meaning and as those words were in 1971. Instead, let's look at 1776. And she's kind of like, wait a minute. That was a long time ago, and we've actually really adopted two constitutions since then. A lot of states have been around since 1776 have adopted more constitutions in the meantime. And so what do we like? What about the words from 1971? And this, neither side really went into it, but this opens this huge Pandora's box that I've talked about in the podcast, my writing a few times. That a couple scholars in this great article from a couple years ago called Interconstitutionalism, where you have a constitution that itself has readopted text from an earlier constitution. And so if you're into original meaning and all that, like which controls? And North Carolina seems, because it's kind of got a originalist like majority that's on fire, it seems, the last couple of years. And this is the latest example. Because there was this turnover at the end of 2002 into 2003, that they're still figuring this out. A state that has worked on this a lot in a good way, I think, in recent years is Georgia. Georgia's Supreme Court has said that, okay, well, we have a presumption that if text wasn't changed from one constitution to another, because Georgia's had like literally 10 constitutions.
Which isn't unusual, by the way, just so our listeners know. It's not unusual for a state to have many state constitutions throughout the course of its history.
Yeah, I mean, Florida's had 4 or 5, right,
something like that,
Justin? Yeah. So they say that you go to the earliest constitution with the same text, but it's just a presumption. You could show that actually you should, and like, because when people readopt a constitution that's a different citizenry, are they interpreting the words as they would interpret it in their daily lives at that day? Or are they just like, yeah, we haven't changed anything, so you readopt the original? Like, are people even originalists in 1971 to think about doing that? I mean, there's so many questions here, right? And they don't really get into that here, but it's something to keep in mind. In your thought about remedies, yeah, I think maybe this case is right in that there isn't a property right to like avoiding the consequences for molesting children. But it does kind of raise questions because we always say at IJ, like, for every right there is a remedy. If the right in the Constitution, that means you should be able to enforce it against government actors, even if your legislature hasn't created a cause of action. And so remedy is pretty closely tied. I think it might be different because that is actually a constitutional right, and here we're talking about common law, tort law. So maybe there's something different there, but it is certainly I'm not totally sold one way or the other, I guess.
Right, and I think I agree on that distinction, and that, in fact, that's the only way I can sort of resolve this in my mind, because like you, I have been arguing not only in that other case that's pending before the North Carolina Supreme Court, we argued that the public use clause was self-executing, not just the just compensation clause, and that once a court says this isn't for public use and you take it anyway, my only remedy isn't in just compensation like the town in that case said. They said, well, now you can sue us for inverse after we just took it anyway. In that case, the property owner was like, "No, I want you to stop. How about that?" And the courts and the lower court said, and the only way to do that is sue and trespass. You can't do that in the course of an eminent domain case. You've had your licks, you win, you're right, it's not for a public use, but they took it anyway. Go sue them and trespass. And the plaintiff in that case, or the property owner in that case, was a lawyer, and she said, I think it's part of my self-executing right to have you guys live by the public use clause. So maybe that's a good, I think that might be a distinction. Or, the way I end up writing this case off, I lump it in with those other cases that we often see out of the federal circuit at the U.S. Court of Appeals for the Federal Circuit, that essentially say, you're a chump, to use the language of Chief Justice Roberts. If you think you have a property interest in legislation, shame on you. The government can always change. If you've, set up your business and your life around certain statutory schemes and then it goes away, that's, you're the fool, and that's not a property right.
Yeah, I mean, Anthony, it's almost the opposite of one of the cases you won at the Seventh Circuit, right? Where when it came to taxi deregulation and allowing transportation network companies to compete, the taxi companies said that this was a taking and that they're entitled to, I think, roughly $1 bajillion for allowing competition. And you successfully argued on behalf of drivers that no, their permits allowed them to operate, didn't allow them to keep out competition. And so in many ways, I see an analogy there.
I got a whole 2 minutes to argue that before Judge Posner, victorious. The corporation of the city of Chicago lawyer got about 18 minutes, but she did well.
But you won.
Too, so we both won.
It was a very important 2 minutes.
We intervened on the same side of the city, unusual case for IJ, but that was good.
That must have been an interesting board of trustees meeting for you guys to get that case approved. We're coming in on whose side now?
Once we did a few of those, I think they got used to it. But I mean, it was probably a little jarring at the beginning. One last thing I will say about this case is the court in its methodology at the beginning, where it lays out all this originalism stuff, the majority, they use this darn phrase that we presume a law is constitutional unless you can prove it beyond a reasonable doubt. And then they never know what reasonable doubt means. And that is very common, actually, in state constitutional cases. And it's not public yet, but I am working on something in this area. I think it's ridiculous standard, and other people have written about how it's ridiculous too. And so I hope to join that chorus soon. But I'll just kind of put a preview there for those the very few who are interested.
Well, Godspeed, Anthony. This probably won't surprise you to hear, but I'm a big fan of Professor Barnett's presumption of liberty. I think that's the correct approach, even if the courts disagree.
That would be great. But even if you can't get there, just have it beyond a reasonable doubt. Like, what does that even mean? Which they never even dig into. But yes, presumption of liberty would be much better. So, but people are not waiting for me to talk about that. They are waiting for Justin to discuss feedlots and fines.
Yep.
So
give the people
for
what they want.
People involved in the cattle industry out there, have ever been on a dairy farm or all that, sometimes they can smell, and so the powers that be sometimes aren't fans of that smell, and so there's a lot of regulation that goes into it, and sometimes that can end up in federal court.
Yeah, thank you, Anthony. And as soon as I saw this, I knew I needed to talk about it, because an issue that is near and dear to my heart that I keep seeing pop up over and over again is the correlation between overregulation and chilling of speech. And honestly, the reason this came to my attention over the years, I've been at IJ over a dozen years now, was because I do so much food truck work. Oftentimes I'll be contacted by craft breweries, right? Because there's this amazing symbiotic relationship between craft breweries and food trucks, where the craft breweries typically don't have kitchens and they want food trucks to show up. And so when towns or cities will ban food trucks, it'll often be the craft breweries who contact me, but they'll say, I want you to sue this town, but you can't say you heard it from me. I can't be involved in any way. I can't speak out publicly. And the reason they say this quite reasonably is because breweries are so overregulated, including at the local level, and require so many variances just to operate that they feel like they have this perpetual sword of Damocles hanging over their head, or if they say the wrong thing, it will destroy their business. And there's no express retaliation that's ever happened, or even any retaliation, but just this overregulation reasonably leads people to keep their mouths shut when they otherwise wouldn't. And it just really bothers me. And so when I saw this case, even though in this case there probably was actual retaliation, not just the chilling of speech from overregulation, I really wanted to talk about it. And as you point out, Anthony, it involves feedlots. And I should say this is a recent Eighth Circuit case. It's Wagner versus Shire. And the panel for this case, they were judges Shepard, Kelly, and Strauss. And it has to deal with the difference between feedlots and pastures. And so for people out there who don't know, I've had the pleasure of litigating agricultural issues a few different times. And the regulations always distinguish between food and feed. Food is something that's for human consumption. Feed is something for animal consumption. And so as soon as you hear feed, you're talking about food for animals, not food for people. And in Minnesota, perhaps understandably, they regulate feedlots different than pastures. So a feedlot is an area, usually it's kind of confined. It's maybe a building or at least some place with an overhang where the cattle all gathers together in a concentrated way, and the farmer or rancher brings out the feed for them to eat. Whereas a pasture, it's a wide open area where you're not really affirmatively feeding the animals, but they're just grazing off whatever grass they find or whatever. And so you can understand why, from an environmental perspective, there would be different regulations for feedlots and pastures, which brings us to the farmer Wagner, who had fight after fight with the state authorities over whether one of his operations was a feedlot or a pasture. I was able to find pictures online. Like it's kind of an enclosed space, but it kind of straddles the line between what you think of as a feedlot and what you think of as a pasture. Not surprisingly, he thought it was a pasture. Not surprisingly, the state government thought it was a feedlot. And so they fight over and over again about this issue. There's a state court case, years ago that results in a settlement. But basically, to make a long story short, what ends up happening is at one point for one of his entities, he wants to amend its use and expand it. And the government denies his permit. And so he ends up going to court. And after like an 18-month delay, the government agrees to give him the permit. After that, he goes and he actually goes to the state legislature in 2019, and he convinces the state legislature to change the law so that his farm now meets the definition of pasture instead of feedlot. And apparently this didn't make the regulators very happy. And they attempt to impose a fine on him of over $150,000. And unfortunately, the opinion doesn't say how. I don't know if this is from a FOIA request, but he obtains internal documents from the regulatory agency where they're talking about how this is the guy that got the law passed in the way they didn't like. Now, of course, that doesn't necessarily mean that that's why they tried to impose the largest fine in Minnesota.
It's a little ambiguous.
History.
They might have just been identifying him. It's hard to tell.
Sure, they might have just been pointing that out, just like FYI, just so you know. This guy that we're imposing the largest fine in history against is that same guy. Could be total coincidence. I doubt it, but you never know. So the farmer brings a federal lawsuit in a couple different ways, right? He brings a procedural due process claim for the delay, the 18th-month delay in issuing his permit. He also brings a retaliation claim, both for the permit delay and for this, six-figure fine, this historically large fine that they attempted to impose on him after, perhaps coincidentally or not coincidentally, my views, talking about how he was the guy who got the law changed the way they didn't like. It gets dismissed. It goes up to the Eighth Circuit. The court rules against him on the procedural due process claim, finding he didn't have a property interest in the change in his permitting. not my favorite part of the opinion, but I get where they're coming from. What really interests me is the retaliation part. The court talks about how he hadn't alleged enough of a causal connection between the 18-month delay and the retaliation. So that part, they affirmed the dismissal, but they reversed the district court when it came to the district court's dismissal of his retaliation claim for the 6-figure fine. And the court finds that he had alleged enough of a causal connection to survive a motion to dismiss. The court emphasized that all you need is a but-for connection. You don't need it to be the sole reason for the action that you're alleging is retaliatory. And he had done enough to allege that there was a but-for connection. And the court also said something, that I really appreciated, where it talked about how hard it is to prove these cases. And oftentimes, even when retaliation exists, it's hard to find the evidence to prove it, which is true. And I wish more courts would realize, because in the past, one of my pet peeves has been, in fact, I think we've even talked about this on this podcast at one point, about how judges are sometimes naive about retaliation, about the relationship between retaliation and overregulation, about the chilling effect of government's actions, and in a way that really infects the precedent in a way I don't like. Here, this panel correctly pointed out that it can be hard to prove retaliation, even when retaliation is there. But this farmer's allegations were enough to survive a motion to dismiss, and he should get to go forward, which, as you could probably tell, I think is the correct approach. So I think, particularly the retaliation aspect of this opinion was really well done. So kudos to the panel.
Robert, your thoughts?
Well, I gotta go back and focus on the property, the due process. It all goes back to, these things as new property, right? Some kind of you weren't entitled. You don't have a property interest for due process purposes because you didn't have a legitimate claim of entitlement. You couldn't force them to do it. So everything discretionary, even if it's being done through the administrative or adjudicatory administrative process, you're not entitled to anything because you don't have property. Well, I prefer the old property, and I wish courts would get out of that new property mode, because invariably it leads them to conclude that anytime the government has some discretion, you got nothing. I would hope from the farmer's standpoint and the perspective, he's saying, what do you mean I got no property? I own this land, and this is affecting my land, and I'm entitled to due process when I'm asking the government to do something.
But for the violations, he would have received this.
Yes.
Like, that should be all you need. I'm right there with you, Robert.
Yeah, I'm an old property guy. So I that part of the opinion stuck out to me as, and thank you for explaining the good parts. But, I fixated on that, and that maybe that's my pet peeve, is I like old property. I like new property too, but I wish the courts wouldn't view due process property differently than they do takings clause private property. Sticks in a bundle. Land ownership is one of those things that should just mean, yeah, you got property. Now the question is, how much were you due in this thing?
So this is very timely for Short Circuit listeners, because just a couple weeks ago we had a case where there was a concurrent. The facts aren't really important, but there was a concurrence by a judge who said that the law used to be that you had property, so old property, and it was circumscribed, but it was vigorously enforced. Now we have lots more property, such as permits or whatever, if you want to call that a property interest. But if we vigorously enforced all of that, you'd shut everything down. So we have this watered down kind of balancing test to protect that property, and those protections then go back and infect how we think about the old property. Would you agree with that analysis? Because in some ways, I'd say even some of us limited government types kind of like having, say, a permit be property because they're really important in our modern era. So you might as well call them property. But is it that like the system just wouldn't work if we had vigorous protection for all of that? And so it's kind of pick your poison, it almost seems.
Yeah, for me, when the more property, the better.
You're here.
Let a thousand flowers of thought bloom. I think that's what the Little Red Book said about certain things, but I think that about
Not a lot of
property.
property.
Yeah, it's
Yeah,
a
no.
staunch protector of property rights. There you
Yeah,
go.
yeah. But I like turning that one around and say, it's one thing, like in what we think of classic new property, government benefits, some government, whether it's government job, entitlements, those type of things. But the problem is, over time, there's been a lot of mission creep as that has creeped over into old property and things that really shouldn't be considered an entitlement or a government benefit. Hey, can I use my land this way? Oh, well, that's a permit, and we don't have to give it to you. It's discretionary. Therefore, you're entitled to no due process or, procedurally or any kind of anti-arbitrary and capricious principle. We can do whatever we want. It's discretion. That's the part that I think triggers me. So, yeah, here it should have been enough to say he has property because he owns land. That's this, classic property vision of property. Could he have a separate property interest in something? I mean, the classic example is one of vested rights. You get a property interest separate. They award you a new stick once, let's say, you get your last discretionary permit in the land use approval process. You get it. And all you need to do is build your property or build your house at that point. And then for whatever reason, they try to take it away or they change the zoning. In that case, I think you've got two property interests. You've got your right to build, which is encapsulated or it's embodied in the permit. That becomes it's crystallized into a second stick. But you also have your land, and if you can't use your land, they may have problems there too. They may have deprived you of property because this is the only way to make use of your land. So I'm a more the merrier kind of guy on this one, and just have to distinguish this situation from classic new property type cases like entitlements and a non-tenured job at I think that was Roth, right? It was a non-tenured job at a state university.
Yeah.
Yeah.
Right.
No, you're not will employee. Yeah, I get that one, but yeah.
I have a final piece of not so good news for this farmer, because I believe, and Justin, you can look at the case more deeply than me, but this is a motion to dismiss. He's suing these officials actually individually for damages. That's why he can ask for damages, even though it's really the state that he's suing. He's suing them in their individual capacities. But qualified immunity has not come up yet. And I'm guessing on remand, that's probably going to be
You would think, but you would also think that they would have asserted that in their motion to dismiss, right? This is an appeal from a granted motion to dismiss. So why did they not assert that? Maybe they're going to wait and assert it as an affirmative defense. But you're right that he will likely have to encounter it. I don't know why he hasn't yet, though.
Yeah, I think often because attorneys such as those at the Minnesota Attorney General's office like to serially throw roadblocks in the way of citizens' claims, and this may be one of those situations. But maybe there's more to the story that we don't.
I mean, you're not wrong. I think we all probably share this pet peeve that maybe the public doesn't know about, which is that many, like 99% of government lawyers view their job in litigation not as winning on the merits, but as preventing the merits from ever being reached. And so your theory might be right, Anthony.
Yeah, we will see. A friend of mine who has litigated with the Minnesota Attorney General's office, as have I, said he thinks their in-house theory is that no one has standing. So whoever you are, you're suing the government. You just don't have standing, and then they come up with
unless they're bringing the case
to argue that. Yes, I know some very nice people at the Minnesota Attorney General's office, so I'm not personally attacking them, but that does seem to be the litigation strategy, as is the strategy of many city council.
This is not a Minnesota specific critique. What I just said, I think, is true of every level of government everywhere in the nation. And it's just something we have to deal with. sorry to get up on my soapbox here, but these individuals typically have taken oaths to uphold the Constitution, and apparently that doesn't factor into this analysis.
Well, we will keep a watch on that case, as we have kept a watch on many cases we have talked about in the last few months on Short Circuit. And so now to close is time for Where Are They Now, which we are trying to do a better job of here on the podcast from time to time, is to update you on where a few cases have gone. So we don't update on every case that, never it got remanded and got settled or whatever, but kind of bigger developments. So one, Paul Sherman, our friend Paul Sherman, a First Amendment expert, talked about this case way back in Short Circuit 332 last July. It was Upstate Jobs Party versus Kaczynski, a Second Circuit case. Had some interesting campaign finance facts and application of campaign finance precedents in Paul thought an unsatisfactory way. Anyway, it went to the Supreme Court, and then it got kicked over, and then finally cert was denied just 2 days ago at the when the orders came out on Monday, February 24th. So anyway, that is the end of that case. Now, a very interesting development. Some of you may remember Gilmore versus Georgia Department of Corrections. This was a case about a strip search of a woman who was trying to visit her husband in prison and was suddenly told, you need to submit to a strip search right now or you will never be able to visit him again.
Wait, it's about a Gilmore girl?
Wait. In a technical sense, I guess that's true.
I have a 12-year-old daughter.
Now, that would be an interesting episode. But this will very much never be an episode safe for television. So she submitted to the strip search, which was incredibly evasive. And it wasn't true that she had to do all this. So this was on Short Circuit 339, which Anya Bidwell presented. You guys can go back and listen if you want. But anyway, that case has gone en banc. There was an en banc hearing just earlier this month in February. And then after the hearing, now I haven't listened to the argument. After the hearing, the court had a really interesting 2-page order where it gave a summary of the facts alleged in the complaint, which are they are not safe for work. They're pretty awful. And then it said that everyone has to agree this is true because based on the pleadings. And then it said, could a jury find that this violated the Fourth Amendment? And then did the officers have, quote, fair warning of the violation? So it was an obvious violation. That is, you can defeat qualified immunity without on-point precedent. It's really interesting that the 11th Circuit does it even after argument. I'm thinking the argument was not satisfactory is probably what happened. So we will wait and see how that comes out. The briefs are just being filed right now. To close, also our friend Joe Dietrich had a case a few months ago, Short Circuit 351, where he was discussing this Rooker-Feldman wild decision from the 7th Circuit. If you can get wild with Rooker-Feldman, it was this case. So he had a cert petition to Supreme Court. That also, unfortunately, was just denied a couple days ago. So that case will not continue. And then finally, we had our good buddy and general counsel Dan Nepper on in the Christmas sweater episode. That if you want to see the sweaters, you can go back to Short Circuit 356, go on our YouTube channel. That was Marin Audubon Society versus FAA. This is the case where the DC Circuit basically said CEQA regulations are totally unlawful out of nowhere, which have been followed for 50 years. So that case went en banc after that, and en banc was denied, but a majority of the judges had a separate statement where they said all that stuff about CEQA regs being unlawful that was in the 3-judge panel. Yeah, that was all dicta. So you don't have to worry about that. And then that's the end of the case. I don't think that's going to go this.
So wouldn't that statement be dicta?
Well, that's an interesting. It was a majority of the en banc court.
Yeah, but he made this statement despite denying en banc review.
Right, and it wasn't necessary for the holding. There is no holding. It was just denied. So is it dicta and dicta, or is it a holding?
And it doesn't look like it was. I mean, resolving a case or controversy because they denied review.
It's an interesting metaphysical question.
It is.
So we'll delve that mystery and others in future episodes. But first, I want to thank Robert for coming on. We promise it won't be 6 years again till you're next invited on. And Robert, if people are interested in your cases and your work, where can they go to find out about that?
Well, you know, the plug you made at the beginning, www.inversecondemnation.com. It's how long it's been around. It's been around almost 20 years. I still say the www part.
It's been around so long. I see you have a sweatshirt with the name on there.
Yes, you know,
is that merch available to fans?
It is. And this is a, it's a one-man operation. So this is, let's say, a beta version of. We made some samples that I have handed out and still have a couple left. And if there's demand, maybe, I don't know, do a second run. I don't know. But yes, it's a mouthful. No question. Inversecondemnation.com. And so now I just point at the logo on my fleecy vest.
That's lovely.
And I have, I'll show you this part. Since we're not on camera, I think you won't see me in my pajamas, but this is the latest thing. We got.
Oh, okay. And listeners benefit. He has a duck hunting hat.
There you go. Hat. So when you're out, in your duck blind, thinking about the latest takings case, you can remember, while away the time, reading a law blog.
What you can think about that, and also if you're in law school, think about contacting Justin to have a Supreme Court preview at your school if you're into that. So thank you, Justin, for coming on discussing.
And obviously, our listeners should know this, but the Supreme Court term starts in October, so these previews would be in September or early October.
Right. It can be a lot of fun. So reach out to him if you're interested, and. In the meantime, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.